thank you once more, and I would like to thank you for this, because I asked, I will have how long time? And 50 minutes and 15, not 50. Oh, it's not so good, but okay, so I see the my time. And first of all, I would like to say thank you, of course, for this nice possibility and these nice words in connection with my presentation. I would like to focus firstly on the Hungarian regulation, but I spoke with Marta Benyus, and she said me that it will be very good if I can say some words about the Central and Eastern European countries regulation and about the other international trends which are important in these days. And so I try this coordinate and solve in this short time. So the first question is if we would like to analyze our regulation, what can we make? Because, of course, this is very important that we are in the middle, not only in Hungary, but our countries too, in the middle of the euro. So we know that the international regulation, international documents, and the opinion, expert opinion of international organizations, and of course the European Union is very important for us. And so this international environment, not only in Europe, but of course in the Central and Eastern European countries circle, is very important too. But we have to focus on the fundamental rights, have to focus on the crime policy reasons and the causes of the regulation, and very important for us, the scientific control. I will show one example in connection with this from Hungarian example, and of course the practice, because this is the most important. We could have very, very nice and good regulations, but this isn't useful in the practice. It's not so valuable for us, of course. So the first is that these questions, I spoke about it short. Okay, then the next, that there are, of course, very different possibilities to protect the children, because our glasses is the children's rights, or in connection with children's rights. So this is an extra point of view in connection with our analysis. But what we know about the international perspectives, we have a very complex system, and we can use different grouping options in connection with these documents, because there are documents which focus on human generally, not only the man, of course, but the human, and only the children. There are general questions or very specific legal field questions, global or local field, and of course the form of these documents is really important, because some of these there are obligatory to us. And we have another grouping aspects too. For example, only in connection with human rights, we can show different regulations and different documents. So this is a very, very complex system. And if we would like to analyze and evaluate of the regulation of Central and Eastern European countries regulation or acts, and of course the Hungarian, this is a challenge for us if in connection with this. So in my presentation, presentation, I would like to focus on special documents, or only one group of documents which focus on only the children, and which are specific or legal field, and especially criminal law, or in connection with criminal law. But on this field, there are several documents too. And in Hungary, we have one group which have become part of national laws, and so this is obligatory for us. For example, the New York Convention, and in connection with these, the Hungarian criminal legal system and the Criminal Legal Act was modified a lot of time, and we have new criminal acts and new measures form, etc., which help to protection of the of the children's rights. But we have international documents too, which having typically a significant influence on national legislation, but there aren't a part of the, for example, Hungarian legal background, the badging rules, Tokyo rules, or for example, the Riyadh guidelines is very important, and the messages is very important. But if, for example, in during the modification activity, we speak about this. Okay, this is important, but not obligatory, and so this is another situation. And the last is, for example, the Leuven Declaration, but we have relative new, the Greifswald rules in connection with the prison rules of juveniles, and this is very important. Possibilities to focus on these, and it would be very important for us. But we have to focus on the Central and Eastern European countries because we know that we have common history and so common experiences. For example, we were in the umbrella of the Soviet sphere of interest, so it means that the consequences of this situation are similar. For example, the social structural legacy or the lasting economic impact. But the political system change in every countries, and in a short time we are very close together, and it was a total shock for every citizens of every Central and Eastern European countries, and joining international interest groups and institutions is a similar experiences too, and similar challenges, and we have to change a lot of things. And if we would like to evaluate this process from other point of view, we can say that extremely short time, 10-15 years, was enough, or maybe not enough, but it was for us to change everything, and the processes were parallel worked. It means not only in the policy or in the economy, but in the society and in the regulation too. But what can we say about the consequences of criminal policy? We can summarize that these countries have a so-called dual-track criminal policy, and it means that diversion and other possibilities of lighter sentences is the reaction for first offenders, young offenders, offenders, and for offenders who committed crime with a low danger level, but we have very strict answers, criminal legal answers, and sanction in connection with crime of repeated offenders. So we have other similarities too on the field of this criminal legal regulation, but if we would like to summarize this, we can say that the protection of children's rights have two different ways. One is the direct protection and indirect. If we would like to focus only on the direct protection possibilities, we can say that we have a multi-level legal protection multi-level legal protection system, and it means that not only in criminal law, but criminal procedural law and the other legal field too, and on the field of criminal law, we have different techniques and measures in connection with this. But indirect protection is important too, and it means that we have to focus on the juveniles who are in conflict with the law, and it is really interesting how different, for example, the minimum age of criminal responsibility in these countries, or how can we understand that we can same roots but partly different responses of these. So if we only see of the Children Rights Convention, we can summarize our evaluation process that I think so on the level of the regulation we have we are in a very good phase. In the practice, this is another question. But about the Hungarian regulation in the last 4 minutes, it means that in 3 minutes, that it means that we have a very important regulation from history, in the history, and we have a very complex system in connection with this, because the so-called patronage association was a very good solution to protect the children who are in conflict, were conflict in the law, and our juvenile criminal justice system was very complex, and we have, I think so, we could be very happy if we speak about this time and this situation, and we have only in 1908 different possibilities from England, for example, the probation system, and a lot of other good solution and good answer to children. So our theoretical roots and basis is very strong, and we can a lot of similarities with the Central and Eastern European countries. We have a good legal historical background, and very important that we focus on the international document too, but this is absolutely normal because we are the member of the European Union. But if we would like to say only some words about the situation of victims and offenders, how can we these analyze in the criminal act, our criminal act, criminal code, excuse me, we can say two different chapters in connection with this. One focus only on the offenders, and we can say that how important is the age, and is the age, and we have only very strict chairman, okay? And this is, and we have, of course, another chapter focus on children victims, and it can see that this is a special system because we have different solution to focus on the age of victims. And only last thing, okay, thank you. So this is example from practice, okay, and this is our child pornography section, and it's very important. And if we create this criminal case, act, we focus on different international documents and the criteria of these questions, etc. And what was our goals? Of course, we would like to protect the minors in connection with this sexual abuse, and we would like to sanction the adult offenders especially. But what we know, that only just a moment, that among the, okay, we are here very quickly, okay? So the very important message of this regulation is these results belong to Professor Zsolt Szomora, who researched this question in Hungary. And what we can say, that the reality is that the most part of offenders are children too. Children under 18 years old. And what is the most important problem in connection with this? That this criminal act has a very, very strict and serious consequences. And we cannot, or not only we, but the court or judges or prosecutor cannot make differences between the offenders. There are, and we can say this, there are some solution or mandatory solution. For example, mandatory disqualification from employment or prohibition, this is most better, prohibition to exercise professional activity. But maybe this is 60 years old. And he will be or she will be never work on the field of several employees. Okay, so. And the future, we have a lot of questions, but we will speak about this maybe next time. Okay? So, and thank you once more, and excuse me, maybe I am a little bit late. Thank you.